one and the Galvin one. Let's see who's who here. All right, counsel, are you both, I think you're both on behalf of separate defendants. Is that right, Mr. Beck?
That is correct, Your Honor.
And Mr. Bush, you're on behalf of Geico, is that right?
Yes, Your Honor.
Okay. Have either of you had any contact with Mr. Zamborski or anybody from plaintiff's firm?
Not regarding this hearing.
No, not regarding this hearing. I know my office is in process, as co-defense counsel is. We're trying to schedule plaintiff's deposition. I do know that. We've had emails going back and forth on that. So we have had correspondence, but just not specific to this hearing.
Okay. I don't see anybody for plaintiff in the Zoom waiting room, and obviously we're a little bit past time. So I don't know, how would you guys like to proceed? I did have this set as just kind of a, a preliminary scheduling conference here today. Did you guys want me to reset this? Do you want to just set some dates and then see if plaintiffs object? Mr. Beck, what do you think?
I think just setting dates at this point, Your Honor, and look, we'll do our best to abide by them. And if plaintiff has an issue with it, or we run into some issue with plaintiff counsel within the dates, we'll be sure to let you know.
Okay. I'm sure they will too. Okay, so how much time do you guys want for discovery in this case? Can you just tell me a little bit about what the case is, what the factual background is, just the basics?
Sure. Mr. Clough is an Arizona resident who was visiting Michigan when he got into an accident. They are asserting no fault benefits and UIM benefits from Geico.
Okay. Is there anything unusual or that you think is going to take more time than a typical case here, or is this pretty standard car accident type situation?
The facts of the accident seem pretty straightforward. Geico's biggest issue is that this is an Arizona policy that they're treating as a Michigan policy. So we're preparing an MSD on that issue. We've already started the discovery process. Other than that, I don't think there's too many issues on our end.
Okay, Mr. Beck. All right. How much time do you guys want for discovery in this case, do you think?
Yeah, I think Mr. Beck froze.
Yeah, it looks like it. Let's give that a second here.
Oop, there he goes.
Yeah, we'll see. He should probably sign back in, I would guess.
Yeah.
There we go.
My apologies, Your Honor. Not sure what happened there.
No problem. Just, my last inquiry was, how much time that you both would like to set aside for discovery?
Yeah, I'll say this, Your Honor. All things being equal, I understand Geico's position on the PIP out of state residents. So, yep, MSD is likely. On the BI side of things, my client isn't disputing negligence on this matter. So at this point, we just need plaintiff's deposition, see what the injuries are, and try and see if we can't resolve this matter. So the BI seems pretty straightforward. I would say 90 days for discovery should be more than enough. Again, so long as plaintiff counsel, is ready to play ball on this one.
All right,
No
Mr.
objection.
Bush? No objection, okay. All right, so we'll set it for 90 days for discovery. I will have the parties participate in a facilitated mediation within 60 days following the close of discovery. So that'll give you time to negotiate on your own if you want before going through the expenses of facilitated mediation. And then I will set this for a status conference following that period set forward for the mediation. So in about 5 months, I'll set it for a status conference. If the case is resolved before then, we can take that down. If not, Mr. Bush, you can file your motion for summary disposition anytime. I'll just make the summary disposition cutoff 60 days after the close of discovery, same as the mediation cutoff.
Good. Thank you, Your Honor.
Any other dates or issues I can address for either of you while we're on the record today?
Not for me, Your Honor.
No, Your Honor. Thank you.
Okay, so I'll put these dates into an order that we've discussed here into an order. I'll send it out to both of you along with the notice of the date and time for the next status conference. I'll also put in the order if plaintiff has any objections to this, that they need to file their objections within 14 days, and then we can address any problems they have with these dates. And we'll go forward from there. Thank you. You're both free to disconnect at this time.
All right. Thank you so much, Your Honor.
All right, our other 130, which is Ingram versus LaFond, I do have in the file a mediation report indicating that the case settled. So I suspect that's why the parties are not appearing today. So we won't set any further dates on this file. Right, Mr. Koss, if you could unmute, please. Thank you. We're on the record in Whedon versus Bissett. This is file number 2514962. The record should reflect Mr. Koss is present by Zoom on behalf of the defendant. Mr. Koss, have you had any contact with defense counsel in this? Oh, wait a second. They just popped in. Hold on one second. Mr. Benzinger, are you able to hear me okay?
I am, Your Honor.
Okay, we've got both counsel present. This is set for a scheduling conference in this file today. Mr. Koss, can you just tell me a little bit about the claims here?
Yeah, there's a motor vehicle accident, Your Honor. My client was injured. He had a, what are we looking at? We have a fractured tailbone, Liz Frank, right foot fracture. No surgery as of yet, but it looked like I think he's still probably going to have a surgery on the foot. And I can also tell you that counsel and I have worked together in the past and have been working together on this one. We've set some tentative dates for depositions already in this matter too. So yeah, we are working forward on this one.
All right, are there any, unusual or novel kind of legal concepts that are going to apply here? Or is this pretty standard in terms of setting dates going forward?
It seems to be pretty routine, Your Honor, as far as I can tell.
Okay, Mr. Benzinger?
Yeah, routine third party, Your Honor.
Okay. What would you guys like to set aside for discovery in this case?
It looks as though the deposition dates were out in June that we were discussing. So certainly enough time to get those done. If that's where we're at, I mean, I can try to make it happen sooner, but that looks like the dates that we were talking about out there. Brad, does that look right to you?
Yeah, I think, I mean, just looking at it, I think 150 days, Judge, we've started a little bit, but I think 5 months is safe.
Okay. Well, let's say 6 months, but we'll include mediation in that time frame. So we'll make the mediation cutoff by the close of discovery at 6 months. And is there anything that needs to be adjusted, amended with pleadings or any parties added?
None from plaintiff's counsel, Your Honor.
None that we know of, Your Honor.
Okay. And Mr. Benzinger, did you want to reserve an IME?
Please.
Okay. Any objection to dispositive motion cut off 30 days following the end of discovery?
No, Your Honor.
No objection.
All right, so I'll set this for a status conference at about that 6 month mark. And do you guys think you'll be able to agree on a mediator? I forgot to ask that.
Yeah.
I do.
Okay. So just pursuant to my standard pretrial order, if you can notify the court within 14 days of the selection, who you've chosen as the mediator, notify us in writing of that. And then, as I was saying, I'll set this for a status conference around the close of discovery, and we can see where things are at and go from there. Mr. Koss, any other dates I can address for your side today?
No, thank you, Your Honor.
Mr. Benzinger?
None, Your Honor. Thank you.
Okay, so I'll put these dates into an order. I'll get that out to both of you along with the notice of the date and time of that status conference. And thank you both. You're free to disconnect.
Thank you.
Your Honor.
Thanks, Matt.
Take care, Brad. Have a good day, everyone.
So that, Weaver file. Ma'am, can you tell me your name, please?
Of course. My name is Chloe Ellis. I am Craig Elhart's paralegal.
Okay. What are you going to be doing here today?
I am actually, Craig requested that I respectfully request the court to wait for him while he handles another matter. He has a very quick and brief Secretary of State meeting at the moment. And he was just wondering if we could have a few minutes for him to complete that, and then he will be on and ready to proceed with the show cause hearing.
Okay, perfect. Yep, we can do that. And I appreciate the heads up because I was wondering where he was. So
I don't look like Craig.
okay, so when I see him appear, then we'll get started.
Perfect. Thank you so much for the courtesy, Your Honor.
You're welcome. All right, Ms. Himick, are you able to hear me okay?
Yes, I can hear you.
Okay. 1 second.
This is Corinne Gillespie and Aaron Sika. We're together.
Okay, great. So we'll go on the record. This is Jones versus Himick. This is file number 2514951. I just need one plaintiff's counsel to put your appearance on for purposes of today, please.
Good afternoon, Your Honor. This is Attorney Aaron Sika on behalf of plaintiff.
All right, and Ms. Himick, you're appearing on your own behalf today?
Yes, I am.
Okay. All right, so this is set for a scheduling conference today. I understand, just looking at the complaint, that this is a partition action. Ms. Sika, can you just give me just a short outline of your claims and what you'd like to see for scheduling going forward here?
Yes, Your Honor. And on the claims, we have been speaking with your staff to notify them of an upcoming motion for partial summary disposition that we will be filing. And we were advised to let you know of that today at this hearing. So we'll be sending that in, and we think that should resolve a good portion of the claims, as there's no dispute as to ownership of the property. The primary dispute is as to split of the proceeds after sale of the property or damages. So our motion intends to leave only that issue if we are successful in that. So we are looking to hopefully schedule a day for that to be able to work it into this scheduling order. But other than that, we are just looking for some standard time for discovery following that motion.
Okay, Ms. Jones, I'm sorry, Ms. Himick, I understand that you're proceeding without counsel today. Do you have any requests in terms of scheduling for how we go forward with the case?
No, I don't.
Okay, so what I'm going to do is just set this for a standard 90 days of discovery. I understand the parties may not need that much time. But I'll set 90 days for discovery. Ms. Sika, any motions, dispositive motions for summary disposition would need to be filed and notice for hearing within that time frame. So that should be enough time for you to get that filed. I can't give you a date for the hearing today. That's something that you would need to contact my office again to get an actual hearing date for that motion. But it would need to be filed and heard within that 90 days for discovery. I'd like to get that motion heard and see where we're at before the court orders mediation. I think depending on the outcome of that motion, mediation may or may not be appropriate. So my intent today would be to just set that initial period of discovery, the cutoff for dispositive motions, and then set this for another status conference at about 90 days to see where things are at. And then if it looks like mediation may be something that's helpful to get it resolved, then we can look into that. Otherwise, we can schedule for a bench trial at that point on any remaining issues. Ms. Sika, do you have any objection to that time frame?
Your Honor, I would suggest, I think we could do closer to 60 days for that initial period of discovery, if the court is comfortable with that, to keep it moving along, understanding that there may be additional discovery after that. We intend to file our motion very soon.
Well, I guess that's why I just want to leave the 90 days. I mean,
Okay.
Again, if we don't need it, we don't need it. But I think that's a reasonable time frame. So, Ms. Himick, again, I understand that you're proceeding without counsel, but do you have any questions about the things we've been talking about here so far?
I don't believe I do, no.
Okay, so basically, Ms. Himick, what will happen is it sounds like plaintiff's side has a motion that they're going to file. You'll have an opportunity to get that and then to file any kind of response that you wanted to. And then we'll have a hearing on the record like we're doing today, where each side will present its arguments. And then if I order mediation, that's just a process where both sides would meet with a neutral third party who would attempt to negotiate an agreement between the two sides. And if that doesn't work, then ultimately the court would have a hearing that I refer to as a bench trial where I would be making any decisions about issues that remain. Do you have any questions about that?
No, I don't. Thank you.
Okay, so I will send out an order that reflects the dates that we've discussed today. I will also send out a notice of the date and time for that next status conference, understanding, Ms. Sika, that we'll probably have a hearing prior to that on your motion, and then we can go from there. Ms. Sika, is there anything else that I can address for your side today?
I don't believe we have anything further, Your Honor. Thank you.
Okay, Ms. Himick, anything further from your side?
I don't have anything. Thank you.
All right, thank you. That's all for today, and both sides are free to disconnect on this case.
Thank you, Your Honor.
Okay, it looks like you got everybody connected. We'll go on the record in Fitzgerald versus Fitzgerald. This is file number 2514963. If I could have both counsel put your appearances on, starting with plaintiff, please.
Sure. Joel Shaw on behalf of Sherry Fitzgerald, who is accompanying us on Zoom here.
Lori Shelter on behalf of Charles Michael Fitzgerald, who is also present via Zoom from my office today.
All right, I have this set today as a pretrial conference. Mr. Shaw, on behalf of plaintiff, can you tell me what the status is and what you would like to request for scheduling going forward to get the matter resolved?
Sure, Judge. I think, well, as you can tell by the file number, this is a divorce without children, so we don't have to worry about the child-related issues. There is property-related issues. I'd like a period of discovery because Mr. Fitzgerald operates his own business, and that's going to require some investigation. And I'd like the court to order mediation to occur not too far into the future. Other than that, I don't know that there's a lot more the court can do today.
All right, Ms. Meltzer.
Thank you, Your Honor. I would agree with Counsel Shraw's statements regarding discovery. I think mediation is appropriate if everyone's agreeable. We do have the outstanding matter, and possibly it's in the mail, I don't know, of the plaintiff's domestic relations verified financial information form, which was due several weeks ago. I sent correspondence to plaintiff's counsel asking that it be supplemented yesterday. I still haven't received it. I think those initial disclosures are pretty critical to get the ball rolling.
And those are in transit to you.
Okay.
All right. If we set this for 90 days of discovery, is that enough time, Mr. Shaw?
I think so. The parties have a home that I expect will be listed for sale. In fact, Ms. Smeltzer and I have corresponded about that, and I think the parties are on the same page that it ought to be listed for sale sooner than later. So we don't need to worry about appraisals or deadlines on that issue, I don't think.
Okay, Ms. Smeltzer, 90 days?
Yep, 90 days will work. Yes, thank you.
Okay. And then is this going to be a community mediation, or do you think we're going to need an attorney mediator?
I'm kind of inclined to suggest attorney facilitated mediation, but I'm not foreclosed to the possibility of community mediation.
Mr. Meltzer, what are your thoughts?
I have really no opinions on that. I do like working with attorneys, but I have worked with the community mediation program before and have had great success. So I'll defer to the court or plaintiff's comfort.
Well, I guess I'll leave that to you guys to discuss. I mean, if you can't agree on community mediation, then I think we would have to go with a facilitator. But I guess I'd like the two of you to take the first stab at an agreement on that, just so that I'm not forcing your clients to spend money on a mediator if neither of you think that that's necessary. So I don't want to order that at this point, unless you both agree that that's a necessary step. So I'm just going to put parties to agree on a process for mediation. And I'll just ask that you discuss that and notify the court within 14 days of how you want to proceed on mediation. And then is there any objection to setting that deadline for mediation at the end of the 90 days for discovery, Mr. Shaw?
No, Your Honor.
Ms. Meltzer?
That's okay with us. That works for us. Thank you.
All right, and then I will set this for a status conference at about 90 days. If the parties have been able to reach an agreement, we can use that date to take proofs and enter a judgment. If not, we can see where things are at and discuss further scheduling at that time. Mr. Shaw, anything else I can address for your side?
No, I don't think so, Your Honor. Thank you.
Ms. Schmelzer, anything further for your side?
Nothing further, Your Honor. Thank you.
Okay, I'll put what we've discussed today into an order that'll go out to both of the attorneys, and then I'll send out a notice for the date and time of that status conference. And everybody on this file is free to disconnect. Thank you.
Thank you, Judge. Have a good day.
Oh, yeah, the 2:30.
Mr. Elhart, are you able to hear me okay?
Yes, Your Honor, thank you.
Okay, and Mr. Weaver, if you could unmute for me, please. Thank
Yes,
you. All
Your
right,
Honor.
thank you. We're on the record in Wright versus Weaver, file number 2414403. We have Mr. Elhart connected on behalf of plaintiff, and we have Mr. Weaver connected on his own behalf. Mr. Elhart, can you tell me, this was set as a show cause, how did you want to proceed today?
I simply want to inquire from Mr. Weaver. We can be put in a separate room, Your Honor. That's fine.
Okay, Mr. Weaver, I'm going to put you into a breakout room with Mr. Elhart so the two of you can have a private conversation. So
Okay.
that's just going to take 1 second here.
Yes, sir.
Okay, Mr. Weaver, are you able to hear me?
Yes, sir.
Okay.
Yes, sir.
Do you know where Mr. Elhart went?
I do not. He just told me to leave the breakout room, sir.
Okay. All right. Did you guys reach any kind of resolution in your discussion there?
Yes, Your Honor. I gave them a settlement offer of $3,500, paid over $1,200 a month for the next 3 months. And he's going to take it to his client. He told me.
All right, let me, I'm gonna see if we can get, I don't know if he got disconnected or what happened. I'm gonna see if we can get Mr. Elhart back connected. So I know you've been on for a while. If you could just hold for just a little bit longer.
Yes, sir.
Thank you. All right, my staff's calling Mr. Elhart's office to see if he can reconnect, so it'll just be another second, okay?
Yes, sir.
Thank you.
There you go. I'm sorry, that's 3.
All right, Mr. Elhart, we're back on the record in your file. How did you want to go forward today, Mr. Elhart?
Mr. Weaver has made an offer of resolution, Your Honor, which I'm going to convey to my client. And he's been kind enough to give me his email address and will confirm whether that offer is acceptable through my client.
Right, and this is all post-judgment collection activity, is that right?
That's accurate, Your Honor.
Okay, so I'm not gonna set any further hearings in this file, unless you schedule them for hearing. Any objection to that?
Not at all, Your Honor. This is a very acceptable means of proceeding.
Okay, Mr. Weaver, did you have any questions?
No, Your Honor, I do not.
Okay, thank you. Both parties are free to disconnect.
Thank you.
Your Honor.
One party's here for 3 o'clock. The other party isn't.
Is it Rosemary?
Yeah. Ryan's not here. I bet she shows up by about 5 too. Oh, he'll be here.
It'll.
All right, I think we have everybody connected, so let's go on the record. This is Parent versus Short, file number 2514932. And if I could just have both counsel put your appearances on, please.
Donald Baranski, Your Honor, P 41101 for Mr. Parent, plaintiff.
Good afternoon, Your Honor. Kate Glancy on behalf of Jesse Short. Covering for
right.
Gary Popovitz.
Okay, thank you. This is set for a pretrial conference in this case today. Mr. Baranski, on behalf of plaintiff, can you tell me kind of what the issues are here and what you'd like to request for scheduling to get this resolved?
Sure, yeah, it was basically my client says he bought this property on a land contract. He says he paid it off and the defendant will not give him a deed to the property. Their claim is that, no, you didn't pay it off. We paid this, that, and the other thing. So we're gonna need some discovery to figure out who paid what. Sounds like an accounting problem, if they got paid or not. Gary called me earlier, yesterday, for defense counsel. He says he wants to amend his pleadings. I got no objection to that if he wants to do that. Either. We just need a little bit of time, I think, to exchange our discovery as far as what payments my client made and who did what.
Okay, Ms. Glancy?
That's essentially a correct recitation of the issues, Your Honor. We are asking for about 14 days just to file an amended pleadings and a counter complaint, I believe, is what the request was, and some time for discovery.
All right, is 90 days enough time for discovery, Mr. Baranski?
It should be. I mean, I'm thinking that, this is what makes this even worse, Judge, is that this is a brother and sister case. I represent the brother and they represent the sister. It's a family thing. So it's a little more complicated than your usual arm's length kind of a deal. So as far as, who said what, when, and what they're going to be doing and all that. So I just want to, these are difficult cases, the court knows, like a divorce case kind of a thing. So anyway, I'm assuming 90 days should be good enough. If not, then we'll come back for some more, I would ask the court, but I'm thinking they've got their records. I mean, but it is whatever it is, we'll just exchange our records.
Okay, Ms. Glancy, are you okay with 90 days?
Yes, Your Honor, 90 days would be fine.
Okay. About mediation? I mean, typically I would order mediation to occur within the time for discovery, but do you want to have a chance to get your discovery done and then maybe see about just negotiating amongst yourselves before I order the parties to go through the time and expense of mediation? Mr. Baranski, what do you think about that?
Sounds like a good plan, Judge. Save people money. If we could do that, maybe we can get this resolved. I like these cases to go to mediation because I had really great experience with mediations. If we have the discovery exchange, it's not a matter, because a lot of times you go to mediation, the mediator says, well, I only know what I got in front of me. You tell me this, that, and other thing. It's nice to be able to at least give that to them, even though we're not doing binding mediation. No matter what I tell, I don't know how much for decades, no matter what I tell the client, they think that the mediator is this power. We keep telling them over and over. You have to make this agreement, no matter what we tell them. So the clients want us to give them all this documentation,
Understood. Okay, Miss Glancy, if I say mediation to occur within 120 days, that'll give you a little bit of time after the close of discovery. Do you have any objection to that?
No, that's perfect. No objection.
Okay. So that's how we'll go forward. I'll set this for a status conference at about 120 days. If the case has not settled, that gives us an opportunity to meet again, see, how we want to go forward, whether that's dispositive motions, just setting it for bench trial or further ADR. So I will send out an order with what we've discussed today, and you'll get a notice of that date and time for that next status conference. Mr. Baranski, anything else I can address for your side?
Well, that'd be great. I think that hopefully we'll get this resolved.
Okay. Ms. Glancy, anything further for your side?
Nothing further. Thank you.
Okay, thank you both, and you're both free to disconnect.
Thank you, Judge. Have a good day. Appreciate your time.
Well.
When they let me know one of the parties is here, the petitioner is here for that.
Gotcha. Thank you. For the 3 o'clock.
Yeah.
Okay, Mr. Biganowski, are you able to hear me okay?
Yes, I can. Good afternoon.
Good afternoon. We'll go on the record now in file number 2514955. This is Galan and Rodriguez versus Engel and Penrod. This is set today for a hearing on a motion for a default judgment and order quieting title. I am in receipt of that as well as the proposed order. Mr. Biganowski, anything that you wanted to state for the record in support of that today?
Oh, Your Honor, I kind of figured you had a question. That's why we had a hearing. Sometimes these orders just get signed and sent.
Yeah, on a quieting title action, I usually have counsel set it for a hearing just to make sure nobody's going to appear and contest it. And so I will note for the record that I did review the file. It appears that service was properly accomplished in this case. There was a default, and so I do think it would be appropriate to enter the order as presented. This hearing was set for 2:45. It is now 2:52 by my clock. No one else is in the Zoom waiting room, and nobody has appeared here in person at the courthouse to contest the motion or the order. So I'll sign that order with today's date. Mr. Biganowski, anything else I can address for your side today?
Nothing, Your Honor. I'll look forward to receiving that in the mail. Thank you for today.
Okay, thank you, and you're free to disconnect at this time.
What?
Thank you, Your Honor.
Donna Jean Lee Hayes.
Isles, are you there?
I am. Can you hear me? Hello?
Can, yep.
All right.
Yep. You able to hear me?
I am.
All right, we'll go on the record in Lamar versus Medley, and again, you're Donna?
Donna Jean Lee Hayes, yes, Your Honor.
Okay, Medley, AKA Donna Hayes.
Well, it's Lee Hayes. It's my legal name is Donna Jean Lee Hayes.
Okay, have you previously been known as Donna Medley?
Not for 38 years, Your Honor.
Okay, but at some point.
Yeah, when I was 17.
Okay, it's not a trick question, okay?
Yeah.
This is a case, I think about maybe some property or something, so your previous name might make a difference, and I just want to make sure we have the right person here.
Okay.
Okay. All right. So this is file number 2514997. Mr. Isles, you're here on behalf of plaintiffs, is that correct?
Yes, Your Honor.
Okay, so this is set for a pretrial scheduling conference in this case today. Ms. Hayes, this is just for scheduling purposes. I'm not making any decisions about the case here today. And were you planning on proceeding on your own, or were you gonna hire an attorney?
No, Your Honor, I'm going to proceed on my own.
Okay. So, Mr. Isles, can you just tell me a little bit about what your claims are here and what you'd like to request for some dates going forward?
Your Honor, my client and the defendant entered into a land contract that they drafted themselves. The house burned to the ground. There's an insurance check. They are in a dispute as to what each of their interests is and how it should be divided, if at all. I filed just enough material to get this case in front of you. The defendant did a memorable job from what I can see of her response in laying out what her position is. My suggestion is that we simply set this for an hour's hearing. I will draft up a trial brief that I will file with you and of course present to defendant to review as to what I can see the issues being and the applicable law. If there's any dispute as to fact, I think that any questions from you can resolve what you believe them to be at the time of our hearing. I'll try to have the applicable law laid out, and I think you can come to a decision as to how the proceeds of that insurance check should be divided.
Is there a reason why we shouldn't have mediation like we normally would to see if the parties can reach an agreement?
I don't see any reason why we shouldn't have mediation. I'm not sure it'll be helpful, but certainly we can do that.
All right. So Ms. Hayes, mediation is a process where you would, both sides would meet with the independent trained mediator. Nobody's required to do anything. You don't have to, they can't force you, to settle or to reach an agreement. But what they try to do is see if there's a middle ground or some negotiation where you could both come to an agreement that's acceptable to both sides. If you do, then that means that's the agreement. The case would essentially be over. Do you have any objection to participating in that?
No, but I would like to address the court that I do have more evidence that I would like to enter in as evidence pertaining to the land contract.
Mm-hmm.
What happened after the land contract and all the proceedings that happened after.
Yeah. So if we get to that point, that's what would happen at a bench trial, where I would take evidence from both sides. The thing that I guess I want to make sure that you understand is there's a lot of rules that govern how and when evidence can be admitted, whether it's witness testimony or documents and so forth. They can be difficult to navigate, and I'm going to be holding Mr. Isles, even though he's a practicing attorney, an experienced attorney, I'm going to be holding him to those rules. And so under the law, I have to hold you to those rules as well. So if we get to that point, if you do have, you know, particular evidence and things that you want the court to take into consideration, it may be, you know, in your interest to seek the help of an attorney, because following those rules, and I can't take that evidence, it might hamper your case or your ability to present everything that you think should be presented. Does that make sense? Okay.
I had talked to a lawyer about this case, and it was gonna be highly expensive, especially what I have sitting in front of me. This documentation of what happened. So he said that I could probably take it on myself of what I can, because it's easier to explain for me and how it happened.
Yeah. And I get that. And if we were just sitting around and just talking about it, you probably could explain it really well. That's not what happens during a trial, though. Again, we have very specific rules of evidence and procedure. It's very different than just sitting down and everybody telling me their side and then me making a decision. So I just want to make sure you know how it would be. You wouldn't be able to just come in with a stack of papers and say, here, judge, this is what happened. Now make your decision. Those each individually would have to be admissible under particular rules, and they would have to be brought into evidence through a witness. And it's a little more complex than just sitting down and talking about it, which is what you're going to do with the mediator.
Okay.
Because that's a much more informal process.
I agree to that.
So, all right. So, Mr. Isles, what I'm going to do is set aside 60 days. I'm going to refer this to the community mediation. They'll be in touch with both sides to get a time and date that'll work for everybody. It'll be by Zoom, so you'll sign in and you all won't be in the same room together. You'll be dealing with the mediator by Zoom. And then I'll set it for another status conference at that point. If we don't have an agreement, then Mr. Isles, we can set a date to have that bench trial and get this matter resolved. Do you have any objection to that, Mr. Isles?
None, Your Honor.
And do you have any questions about that, Ms. Hayes?
Get down here and they have all these jobs. If you want to look for business,
Your own library or something like that.
Okay. So I don't have a computer or nothing at home, so we'd have to do it on the phone.
Yeah, you can use the phone. Yep, that works well with Zoom. So you'll get a contact from the mediation service, and then you'll also get a notice from the court for the next hearing date. Okay. Thank you. That's all for today. Mr. Isles, you're free to disconnect at this time.
Thank you, Your Honor. You have a good day, everybody.
Thank you. Thank you. All right, Mr. Williams, I'll see you later.
Okay, see ya.
Have a good one.
You too.
Thank you, Your Honor.
Thank you. Mr. O'Mara, are you there?
Good morning, Your Honor. Can you hear me? Good afternoon.
Yes, I can. Thank you. And Ms. Honig, are you making an appearance here today?
Yes, Your Honor. I'm appearing on behalf of Double D Whitetails LLC.
Okay. Did you file an appearance yet?
No, my client retained me today, so I haven't had a chance to file an appearance.
Okay. I will ask you, I know that you've made your appearance here on the record, which is fine, but if you can follow that just with a written appearance so we have it for the file, and that'll just ensure that you're receiving copies of everything.
Understood, Your Honor.
Okay. Mr. O'Mara, how did you want to proceed today on your motion?
We'd like to proceed. I don't know if sister counsel, I don't know what she plans on answering, or do you mind if I proceed, or do you need time? If you need time, I would ask that the court at least grant some injunctive relief to make sure that the property is not transferred to anybody else in the interim. But
All right,
Your
Ms.
Honor,
Honig?
I would request time to file a response. I have no objection to my client being prohibited from transferring any property. Mr. Dobson is in bankruptcy, so he already can't transfer his own personal property. I'm not sure there's much else the LLC owns at this point in time.
Currently, the owner's another LLC. So and you're just filing in for Double D Whitetails, not DDR of Lake LLC, correct?
Correct.
Okay. So I guess with that, if you don't mind, if I could make a brief record and argue the motion, and then, Your Honor, I'll leave it to your discretion, obviously. I'll be brief. It's a fairly straightforward argument made. And I'm sure you've read the briefs. I would rely on the briefs. I would just point out that under either MCL 566.34, which is the actual intent to defraud, or 35, this transfer would be deemed a fraudulent transfer. It is transferred for $1 from the defendant debtor at this point, well after the claims of plaintiff, and it's transferred for $1 to an insider, his spouse. So these would all qualify as a fraudulent transfer. What we're ultimately going to be asking the court to do is allow us to execute on this property. But beyond hearing testimony, I suppose, as to any ownership interest in the LLC, which I think it is just the sole LLC that is owned by Dennis Dobson's wife, Kimberly. I don't know what other issues we would likely have or what evidence to bring, but if the court wants to, I guess, hold a hearing regarding that aspect of the LLC that it was transferred to, I would point out that the LLC was seemingly created and is solely owned by Kimberly Dobson. The registered agent is Kimberly Dobson, spouse of Dennis Dobson, who was obviously was a defendant and now a defendant creditor to plaintiffs, and that the registered agent's address for the LLC is the property that they resided at and is the property that was transferred, that we're not claiming, that we believe with pretty much certainty that it was fraudulently transferred to avoid us as creditors. So with that, I'll leave it to you, Your Honor. We would ask the court to at least enjoin the transfer of the property, because currently DDR of Lake LLC, we would not want to see that transferred to anybody else currently. Like that, there should be some sort of injunction in place that the property in dispute not be allowed to be transferred until
Thank you, Ms.
Thank you.
Ms. Honig, anything else you wanted to add?
Your Honor, the same day the transfer from Double D Whitetails LLC to DDR of Lake LLC took place was the same day the land contract vendor transferred the property to Double D Whitetails LLC. Also, a mortgage was taken out by DDR of Lake LLC at the same time. So I would argue it was not with an intent to defraud, that it was part of a transaction to pay off the land contract where a balloon came due. And I can certainly provide those documents along with a response if I have time to do so.
Briefly to that point, even if it's not with an intent to defraud, it is definitely qualifies under 566.35 then, in that it was transferred after right, after our claims for $1, right? So it qualifies under the common fraud aspect of it. So either way, our point is it's a fraudulent transfer no matter what way you slice it. We're happy to prove that what it was done with the intent of defraud, and we would hit those factors. But irrespective of that, it would still fall under the MCL 566.35, which is merely that you transferred property for no consideration. And you're basically now you're insolvent. So we qualify either way. But I'm happy to, if sister counsel feels she wants to brief this matter and reply, I do hesitate because this is drug on for a while. And seemingly there are delay tactics yet again. Now that kind of the, that we're in the end stage here, but anyway, Your Honor, I'll leave it to you. I generally would give, and I'm not against giving Ms. Honig some time to respond. I generally treat counsel with, I understand getting retained late, but it's just that this client has delayed for quite a while, and seemingly yet again on the eve of a hearing, lo and behold, this will be put out another month. And I do want to ensure that my client's interests are protected in the interim.
All right, so I've had a chance to listen to the arguments of counsel here. Ms. Honig, none of this really applies to you. I can appreciate that you've just been brought on this case. And I know that none of the delays are attributable to any actions on your part. So I'm certainly not in any way casting aspersions on you or the way that you've presented your side here at the hearing today. But this case has been going on for a long time. Your client has had numerous opportunities. The court did delay ultimate disposition of this matter a number of times for a number of months to give your client an opportunity to retain counsel. He never did that. He stopped appearing at any of the hearings. And then, his retention of counsel here on the day of a hearing or the day before a hearing or however, I forget whether you said it was today, Ms. Honig, or yesterday, but very recently, certainly not enough time for you to file an appearance, let alone file any kind of written response and the opportunity for Mr. O'Mara to respond to it. Today is the date and time set for this hearing. It was properly noticed. The defendant had an opportunity to retain counsel with enough time to file an appropriate response and have counsel prepared and able to respond meaningfully, both in writing and orally here for the purposes of this case. So in my view, the defendant's retaining counsel, in the final hour here before this hearing was going to take place, and even in light of counsel's appearance, in my view, defendant has essentially waived his ability to argue this issue. Because again, he's had more than enough time overall to retain counsel, more than enough time to contest this motion. Retaining counsel and having counsel appear at this hearing at the last minute, in my view, is an attempt to further delay something that's already been delayed. And a defense in this regard, really, in my view, is no defense at all. And I counsel, I'm not placing that on you, I'm placing that squarely on your client. So for those reasons, I find it would be inequitable and prejudicial to Mr. O'Mara and his client to further delay this. It would result in additional fees to his client, who's already had to, I'm sure, expend a lot in fees to get to this point. So I think allowing further delay in light of the defendant's numerous opportunities to defend and in a timely way, again, would be inequitable and prejudicial and result in expenditure of unnecessary attorney fees by Mr. O'Mara's client. So any remedies you might have, Ms. Honig, from a post-motion standpoint, you're free to pursue those on behalf of your client. But for purposes of today's hearing, the court is essentially going to treat this as an uncontested motion and grant the relief as requested in your motion, Mr. O'Meara. I don't know if did you file a proposed order with the motion? I didn't see one with my judge's copy.
I have not. I'll 7-day it today. If that's okay.
Yep, that was what I was going to request. So if you'll submit an order pursuant to court rule, that will conclude this hearing, and all parties are free to disconnect at this time.
Thank you, Your Honor. Have a great day.
Thank you.
All right, that concludes our afternoon docket. The court will be in recess till 9 a.m. tomorrow.